But the information I'm going to give you really dovetails into what Chuck was talking about, but comes at it hopefully from a little bit different perspective. It puts it more as to what I, as the judge, look to the appraiser to do and what the appraiser is doing there. But how do we get a case? Somebody files an appeal. You file your complaint. You, as the appraiser, probably haven't even seen the complaint or the property. But what happens early on in the case is I'll have a pretrial conference with the attorneys. At that pretrial conference, I establish discovery dates, discovery end date, when you've got to exchange all of your discovery. Separate and apart from the discovery, there's an appraisal exchange date. You're certainly not going to do your appraisal until after all the discovery. If it's income-producing property, you're going to want the leases. If it's sales, you're going to want some comparable sales, whatever it is that you're seeking in that discovery. So then I'll give additional time for the appraisal exchange date. Then I'll have depositions. I don't know how many of you have been involved with depositions, but a lot of times the experts are deposed. That comes after the appraisal reports have been exchanged. So those are 3 dates that I work with. Then I have a date for substantive motions. If someone's going to move to strike the appraisal report, they have a motion we call motion in limine. That means before trial, about a person as a witness, and they don't want that witness to come in, not have the proper credentials. Chuck was talking about USPAP. I had a substantive motion filed in a case. In the appraiser was licensed as a residential appraiser, but not as a general appraiser. The property was a single-family home that had been converted to a dentist office. The appraiser was licensed to do single-family homes. The appraiser valued the property on an income approach, comparing it to other properties, other income-producing properties. When they came to court, the attorney for the municipality sought to not allow that appraiser to testify. I had no problem with the appraiser testifying. Licensure is not something that I, as a judge, have anything to do with. That's what the state real estate board does. They do the licensing. But what I told the appraiser is I'm not going to make a determination if you're licensed to do that type of issue, but that type of appraisal. The issue is raised. What I will do is I will send a copy of the transcript to the realtor board and let them make the determination if you were violating your license requirements or not. And I, as a judge, I'm obligated to do that. I'm obligated to do that if I think someone's committing perjury on the trial, to send a copy of that transcript to the prosecutor. If someone says they haven't filed tax returns in the last few years, I'm obligated to send that to the appropriate authority. So it's the same thing when it comes to someone who is licensed. But the attorney has to bring that motion on a little bit earlier. What the pretrial conference also does, it allows the case to keep moving forward. Attorneys, and you all work with attorneys, I'm sure, are notorious for waiting till the last second to get something done. Call you up at the last possible moment saying, I need an appraisal report for tomorrow. By having a conference along the way, the attorneys have to start focusing in, and I ask pointed questions about, has an appraiser been engaged? Is the appraiser working? What are we doing? And it also lets me know if there's anything important about that property. Does it have environmental issues? Is there some structural issues? You saw the photo of Chuck's home there. That's got some structural issues. It may take longer to do an appraisal. Is there a cost approach going to be undertaken? And say it's a corporate headquarters and you're doing it on a cost approach. You have to have a cost estimator go out and look at the plans for that particular building, how it was built, when it was built, what additions were made, what changes were made internally. That takes time. I need to know that early on, and the appraiser needs to know that early on. So that's why I have the pretrial conferences. Then at trial, you've all been to trial. You go forward, you put your testimony on, and it moves forward. Then after trial, I have the attorneys submit post-trial briefs. And they'll tell me what happened in that trial. They'll tell me what they believe are the facts that were established. So they give me a proposed finding of facts. And they give me the conclusions of law, what was going on in that trial that they proved their case. The appraiser needs to be involved in that development of that finding of fact and the conclusions of law. The appraiser is going to tell the attorney what the facts were and where they've come in. And I've seen when the two get together and work as a team, the product that comes into me is much better than just the attorney writing it on his own. So you need to be involved with the attorney at that time. Trial is something that you think you're doing is talking to me in the courtroom. You're getting questioned by the town's attorney or by the appellant's attorney. But you're actually trying that case before 2, maybe 3 other courts. Because an appeal may be made, an intermediate court, appellate court, or to the Supreme Court. You don't get a chance to testify again. This is the one time you get to say what you want to say and how you put it in. So it's very important, as Chuck says, look at your report. Be prepared. Be able to talk about everything that's in there, because you're not going to get another opportunity. This is it. And I make that determination. Remember that you're an expert. You're not an advocate. You're not trying to prove a particular point or carry your client's position. You've been hired as an independent expert to come in and give a fair market value for that property. That's all you're doing. You're not making those points. The attorney will make those points. An expert in most jurisdictions is one who will assist the trier of facts to understand the evidence or to determine a fact and issue. You qualify as an expert by your knowledge, your skill, your experience, your training, or education. And the testimony that you're going to give must concern a subject matter that is beyond the ken, the knowledge of the average juror. The field testified to must be at the state of art that such an expert's testimony could be sufficiently reliable. You can't have junk science. You can't be making alchemy up and going on. And the last part is the witness must have sufficient expertise to offer the intended testimony. That doesn't mean if this is your first time that you're coming in to testify as an expert that you're not going to get the opportunity. But it means that you have to have some experience. What kind of training? And you're going to have to tell the judge on the qualifications for the expert. What are your training? What's your educational background? What's your work experience? How many years have you been doing appraisals? Where have you done appraisals before? Have you qualified in any other kind of tribunal that qualifies you to be an expert? Maybe not a New Jersey tax court, maybe a county boards of taxation, maybe at a zoning board or a planning board or some other type of entity that would qualify you as an expert. That all comes in. That's all important. It's your training, knowledge, skill, and experience to let you come in. Why do you need to come in as an expert? What are you doing? You're giving an opinion of value. A layperson can't give an opinion in most circumstances, and we'll put the legal part where a layperson can. Fact issue, was the light red, was the light green when you go through the intersection? That's easy, that's a fact. Here you're giving an opinion. You're saying, I've looked at other information, and from that information, I've developed my charts, my graphs, my adjustments, and now I opine a value. You're giving testimony that really is hearsay. You're relying on hearsay information, something that if a layperson came in and wanted to tell me about the sale next door and what it sold for, they're not going to get that opportunity. They would have to have someone come in who was part of that sale, verify the deed. Yes, I sold the property. I sold it for this, and this is what I did. But you as an appraiser can go and speak to those persons and come in, and you can tell me about that. I spoke to thus and so, and that person said this. And it's something that you rely upon so that you can get that in. That's the importance, is that you have that experience, skill, and training. But it's also important to make the distinction by what you know, between what you know as an expert, what you've gleaned from all that background and knowledge, and what you believe and know as a layperson. As we talked before a little bit about the bathroom. You may very well know that a bathroom is going to cost $10,000 because you just put one in your house. That's not going to carry the day when you want to make that adjustment for a bathroom. You've got to make that distinction, separate them apart. What it is that you've relied on and how you relied upon it. Your role is to contribute to the insight of your specialty. You're not there to try the case. You can give an ultimate opinion of value or an ultimate opinion as to the determination that the court has to make. You're given an opinion. Don't go beyond your role. Don't go beyond your expertise. Examples that I have seen, vacant parcel of land can be subdivided into 1, 2, 3, 4 lots. Well, the appraiser looked at the zoning ordinance and said, oh, I got to be 100 by 100 foot lots. It said, I can get 3 of them here. And then went and did valuation. It's not happening. You're not an expert. You're not a planner. You're not an engineer. You can take that information from the planner and the engineer and say, I spoke to the engineer, they did this, they did that, and I relied upon that in determining the number of lots. But you can't go outside your expertise. And don't let your attorney put you outside your expertise. If you're on the witness stand, don't let the other attorney ask you a question that goes beyond or outside your expertise. Tell them, I don't have that expertise. I'm not an expert in that area, and explain why you're not. So if the attorney says to you, well, couldn't you get 4 lots out of this? You said 5, but you really can only get 4. No, that's beyond my expertise. I relied on the planner or the engineer, and this is what I have. Explain why you can't answer the question, but don't get pulled in or sucked into coming into those types of issues, because it's going to hurt your credibility.
Just real quick, it's not uncommon for an attorney or a client to want to save money and try to make you the expert on zoning, planning, if that's what the case is about, environmental issues. you don't really want to be that witness if you don't really have that expertise. The judge is, it's also going to be uncomfortable for you. It's really not in the client's best interest. Have those other experts.
Very important, very, very important. You have to base your opinion on facts or other data. This information can be made known to you during the course of a trial. Some experts can get it that way. But generally from the appraisal field, it's information that you've gone out, you've done your due diligence on your sale, your comp sales, and you're able to tell me what it is that you have relied upon. This is so that I can evaluate the validity of your opinion. So remember, I don't have to accept your opinion. It's only your opinion. I can accept some of it, I can accept all of it, or any parts therein. So that's why you've got to develop each one of your parts and your adjustments, whether it's on a sale of a single-family residence or an income-producing property. Give me everything that you possibly can, because you're going to get past a motion that says you've given me a net opinion, and then I'm going to have to make the tougher decision of going in and giving weight to your opinion. And if you've given me enough data to show how you got to that opinion and why, you may get more weight than the other side, or maybe I'm going to look at both and come up with my own number that would be put in.
And I think the judge will probably give you more weight to your opinion than, you know, either your kids do to your opinion or your spouses. So this is, for me, the only time when I get to testify that someone actually cares what I have to say. Because when I'm home, it's like, hey, I had this big trial. It's Chuck, take out the garbage.
So what I'm saying is you've got to give the whys and wherefores of your opinion. Why you did it, what you based it on. Very, very important. The gentleman in the first row talked about the Greenblatt decision. That was really my opinion that said, Mr. Appraiser, you didn't give me the whys. Why did you do this? How did you get there? And you didn't give me the wherefore. I did all this. This is the whys. Now the wherefore, I did that. And didn't get that, and the case was dismissed.